We will start the session. In fact, as I already told, recently in a parliament, the legislation was passed with respect to the labor code, and as I already said, it was divided under different codes. One code we already discussed, that is the Industrial Code 2020. In a Industrial Relation Code 2020, as we discussed earlier, so three legislations which was merged with the Industrial Relation Code. What are they? What and all legislations merged with the Industrial Relation Code? Industrial dispute.
Industrial dispute, trade union and industrial employment.
Right. Good.
Yeah,
Good.
standing order.
Exactly. So Trade Union Act and Standing Orders Act, it was merged with the Industrial Relation Code 2020. Industrial Relation Code 2020. So we know that what exactly the purpose for which these legislations was passed. The Industrial Dispute Act, we could see the provisions with relating to the strikes, lockout, layoff, retrenchment, and various authorities or machineries to settle the industrial dispute. So these part we discussed under Industrial Dispute Act. And Trade Union Act, we know that the registrations of trade union and purpose for which the general fund and political fund could be used. And the standing order, of course, we know that it is the contract of an employment or the service rules. I mean, standing order which defines the relationship between employer and employee, pertaining to various other aspects like the nature of work. I mean, in the sense like their designation, or say whether he's a permanent or a temporary or casual worker. And in case the probationary period, it should be well defined. So these are all things we discussed already. I mean, the purpose of this standing order, as we discussed, we should define in advance what exactly the terms and conditions while employing the workers or employees. So those things we discussed in a Industrial Relation Code 2020. Another code passed recently, that is a code on the Social Security 2020. We will discuss one by one. That's what, along with the code, I also use the earlier legislations. So accordingly, I mean, we'll discuss one by one. So we'll discuss the code on Social Security 2020. Before discussing the content of this, the Employee Compensation Act of 1923, we'll discuss what are legislations was merged with the Code on Social Security 2020. That we'll discuss first. This, I mean, Code on Social Security 2020 includes the following aspects: Employee Provident Fund. Earlier, we had Employee Provident Fund Act and Miscellaneous Provisions Act. We had. So this Employee Provident Fund was merged with the Code on Social Security 2020. Second legislation, the Employee State Insurance Act of 1948. The ESI Act was merged with the Code on Social Security 2020. Another legislation, the Payment of Gratuity Act. Payment of Gratuity Act was merged with the Code on Social Security 2020. Another very important legislation, that is the Maternity Benefit Act of 1961. Very interesting. Maternity Benefit Act. And one more legislation, that is Employee Compensation Act of 1923, is also merged with the Code on Social Security 2020. Employee Compensation employee compensation. Look at. Employee compensation. How many legislations? What they did? Intention, you just see, they wanted to put all these legislations under one umbrella. They wanted to put all these legislations under one umbrella. That is Employee Provident Fund Act, Employee State Insurance Act, Payment of Gratuity Act, Maternity Benefit Act, Employee Compensation Act. Here we'll discuss one by one: Employee Provident Fund Act, ESI Act, Gratuity Act, Maternity Benefit Act, Employee Compensation Act. So employee, as an employee, what exactly the benefits they're entitled to get? So that we are going to discuss in this session. I mean, the Code on the Social Security 2020. We'll discuss one by one. What I'll do, I'll take it from the last, because see, in this Code on Social Security 2020, chapter wise you can see. Chapter wise you can see. In this case, chapter wise in the sense, Employee Provident Fund and provisions with relating to Employee Provident Fund deals with chapter 3rd. Chapter 3rd. Employee State Insurance deals with chapter 4th. Deals in a chapter 4th. Gratuity, chapter 5th. Maternity benefit, chapter 6. Employee compensation, chapter 7. What is this chapter? This is chapter under Code on Social Security 2020. So you may ask now, what exactly the chapter 1 and chapter 2? In a chapter 1 deals with all these like definition part, who is an employee, who is an employer or dependent, all these, the definition of wages, those things, all the definition part deals in chapter number 1. Chapter number 1. Now, chapter number 2, all like social security organizations, Provident Fund organization, etc., etc. All social security organizations in a chapter 2. Chapter 2. And while discussing definitions, we know that in earlier also we were discussing first like definition, and after that we moved into the contents, the provisions. So similarly here also we'll discuss the definition, and after that we'll move into the legal provisions or rules with relating to these aspects. These aspects in the sense Provident Fund, State Insurance, Gratuity, Maternity Benefit, and Employee Compensation Act. Is it clear? So any questions? Because I wanted to make it very clear, I wanted to update you, and I don't want to explain very outdated the provisions, because recently it was passed, and accordingly, because tomorrow you may not have any confusion. What is this Code on Social Security 2020? And we studied different things, and we studied like entirely different sections, because in a Code on Social Security 2020 you don't find any sections. You'll find just a clause. All these clauses you can find. Clauses. When you look at chapter number 1, definition, clause number 2, all these definition they discussed under clause number 2. And here also all these clauses. Henceforth, I am not going to discuss any section wise. I am going to discuss the clause. So in fact, all these definition they defined under clause 2, subclause. Suppose now today in today's session we are going to discuss about the dependents. Who are dependents? So dependents defined under clause 2, subclause 24. Clause 2, subclause 24. Similarly, Here, employee compensation we are going to discuss today under clause 74. Clause 74. Understood?
Yes, sir.
Yeah. Any questions before moving ahead with the content of? I'll start from the Employee Compensation Act. Employee compensation. I mean part. I mean which deals with the last part. I mean chapter 7, and we'll discuss some. I mean for your understanding, I told. I'm not going to discuss in sequence. Not required. So today we'll take the employee compensation now. Fine.
Sir, you said defendant under clause 2, section the subsection 24.
Clause
that
2,
comes,
subclause
subclause under 24. That comes under the main social security, right? Not
Exactly.
under employee compensation.
No,
correct?
that's what. Henceforth, I'm not going to discuss as Employee Compensation Act. Just for your understanding, the title I have put Employee Compensation Act of 1923.
Okay, sir.
Fine.
Yes.
Because I said even in a industrial relation code, the most of the provisions they kept as it is. They're not changed. And you don't find like similar sections, you don't find. And here and there, they made some changes, as we discussed in Industrial Relation Code 2020. Here also some changes you could find. Some changes. But 95% of the provisions is same, but you don't find the exact same section, you don't find. Because when you look at Employee Compensation Act of 1923, this dependent was defined under section 2, subsection 1, clause D. You could find all the meaning of the dependents, overall dependent. But in this case, I mean, code on social security, that's what I said. You don't find any sections like what we studied under legislations, but you find all these clauses you find, which discuss under a different chapter. I think like we'll discuss, you will understand once we started the discussion on these aspects, these chapters, Prudent Fund, ESI, gratuity, or maternity benefit, and employee compensation. So we'll discuss one by one. Okay. Now, Employee Compensation Act 1923 or on Code on Social Security, they named employee compensation. I mean, employee, they are entitled to claim for compensation. Here, compensation, we are not talking about in terms of a salary or the wages. Here, compensation means the damages, the monetary compensation during the time of an industrial accident. Suppose if any employee met with an accident, when I say an accident, it must be an industrial accident. It must be an industrial accident. Or suppose because of, I mean, there must be an accident. What do you mean by an accident? Meaning of an accident? There must be some incident which must be unintentional, right? I mean, accident in a sense, it is unintentional. There must be unintentional mishap, or it must be unintended. The mishap must be unintended. That's what we call it's an accident. And due to this accident, some personal injury might have happened. Injury, or this particular accident resulted with the death of an employee. Death. Now, during the time of an injury, how he can claim for a compensation? When it comes to an injury, once again there are different types of an injury. maybe a partial injury. They may be partial injury. Once again, this injury may be temporary or permanent. So those parts we are going to discuss. Or the injury may be total. Partial injury further classified into the temporary partial injury and the permanent total injury. So meaning of that we'll discuss later. And total injury in the sense totally a person's capacity to earn is get reduced. In the sense that particular injury which incapacitate a person from doing any work, whatever the type of work, he was completely like incapacitated to do a work, the total injury. So we'll discuss those things in later part. And one more thing, the accident also may lead to the death. Now the question comes, during the time of the death, who can claim for a compensation? Who can claim for a compensation? In case if you don't define this term, who can claim the compensation, what I mean to say, the dependent. In case if you don't define the term a dependent, tomorrow an employer may receive or a commissioner may receive a number of applications to claim for the compensation. That's what this particular the Code on Social Security 2020 defines in a very clear way. Under subclause the 24, it defines the term dependent. Who can claim a compensation, claim for compensation during the time of the death of an employee or during the time of the total injury? Who can claim for a compensation? So here compensation in the sense, when they can claim for a compensation they can claim some accident must happen and there must be, which must be resulted either in a injury or death. So during these two occasions, of course, employee or dependents of an employee can claim for a compensation. So first of all, we'll discuss who all falls under the clause 2 subclause 24, I mean the dependents. Who can claim for a compensation during the time of the death of an employee or total injury or total disablement, partial disablement and total disablement. Any questions? Here, two occasions, employee or dependents can claim for a compensation. What are the two occasions? One, either it must be resulted in a
injury or a death.
Injury or death. Once again, injury also can be classified into two, a partial disablement and temporary total disablement. The meaning of that we'll discuss in future. Clear? We'll discuss now the who is dependent under the Act. Who is dependent under the Act? Dependent means any of the following relatives of deceased employee. I repeat the word, the following relatives. In the sense, the kinship need to be taken into consideration here. Relatives of the deceased employee can claim for a compensation. Now, look at. Very interesting. Who can claim? Who can claim? A widow. A widow can, widow got an absolute right to claim for a compensation. Widow got a right to, she got an absolute right to claim for a compensation, widow. During the time of a death of an employee, a wife, being a widow, she can claim for a compensation. She got an absolute right. The question comes whether during the time of the death of an employee or husband, to what extent widow or wife was dependent upon the earning of the deceased, husband, is completely irrelevant. Wife, she need not prove before the court of law tomorrow whether she was dependent or not. Whether she was dependent or not, it is not material in this case. She got an absolute right to claim for a compensation. I repeat my word, whether widow, whether she was or she is dependent on the earning of the deceased or not, it is not important. The important, being a widow, so she got an absolute right to claim for a compensation. I repeat, whenever I utter a word, a compensation under the Code on Social Security 2020 or the Employee Compensation Act of 1923, there must be what they need to prove. They must prove that there was an accident and which resulted in injury or death. So that they need to prove before the court of law. So widow. So widow can claim for a compensation. Now question comes, what happens in case if there is a case of remarriage? Remarriage. Hope I am communicating. Remarriage. Whether remarriage of the widow which disentitle her to claim for a compensation, that is the question. Whether remarriage of widow which whether it disentitles the widow to claim for a compensation or not. Number of occasions, court said the remarriage which will not disentitle a widow to claim for the compensation under the Employee Compensation Act of 1923. I repeat my word. The court said it is not relevant whether she remarries or not. It is not relevant. The relevant fact of the matter here, relevant is that during the time of death of an employee, whether she was dependent on, whether she was, the remarriage is not at all important here. It's not at all important. One more thing, whether she was dependent or not, that is also not relevant here. Not relevant. As I said, being a wife, and during the time of the death of a husband, so being a widow, so she got an absolute right to claim for a compensation. The question comes, during the time of the death of an employee, so whether she was dependent or not, during the subsequent events. What is the subsequent in this case? Subsequent event is remarriage is a subsequent event. Whether this subsequent event which disentitles her to claim for a compensation, my answer is no. Answer is no. Still, she can claim for a compensation because during the time of the death of husband, she was dependent. And interestingly, one more thing, as I already said, she need not prove whether she was depends on earning of the deceased or not. That is also, she need not prove before the court of law, because these are all people falls under the first category. First category. So widow. Questions? Sir? Because no defense can be taken in order to defeat her claim. That's it. You cannot take any defense before the court of law. And she need to prove that, I mean, she was a wife, that's it. She's a widow, that's it. That she need to prove before the court of law. And remarriage is not at all a bar to claim for the compensation under the Employee Compensation Act or the Code on Social Security 2020. The amount of compensation we'll discuss later. How much you can claim during the time of the death or whatever. I mean, this particular the code or in a schedule you can find for what injury, what compensation can be claimed. Suppose, I mean, employee himself or the dependent, how much compensation can be claimed, how to calculate the compensation amount, which is decided in advance. In case if a person lost his forefinger, what exactly is a loss in earning capacity already decided. How much he or she can claim for compensation, it is already decided. That's what. These are all people falls under first category. So we discussed widow. Now the next person, a minor, legitimate or adopted son. Any questions here?
Sir,
please.
Sir, that subsequent remarriage of widow, she is entitled to get the compensation, no, sir?
Yes, exactly.
So what if she is divorced before the death of the employee?
No. See, this is what subsequent event, as I said. Subsequent event, I said. In case if there is there was a separation before the accident, no question of this one is which will arrive.
So in that case, who will be the dependent, sir?
Sorry?
In that case, who will be the dependent? If
see, in case, as I said, a widow, suppose in case if there is any divorce, and say in case she was getting any maintenance from the husband, in case if she is not married, if that is the case, of course she can claim for a compensation, because she can prove that she was dependent. That I'll discuss in a next category, third category I'll discuss.
Okay, sir.
Fine. Yeah. So we are discussing like one by one the categories. So I hope you understood the widow and what the context or extent she can claim for a compensation.
Yes, sir.
Yeah. Next, the minor, legitimate or adopted son. Earlier this provision was not there, adopted son, because while after the Indian Adoption Act of 1994, so this particular clause was added. So minor, legitimate son, it also includes the adopted son. I repeat my word, the minor, legitimate son. What do you mean by legitimate son? What do you mean by legitimate son? What do you mean by legitimate son? In the sense, after the consummation of their marriage, in case if they have any son. After the consummation of their marriage, in case if they have a son, so son we can say that a legitimate son. Or in case if you adopt any son as per the Indian Adoption Act, so we can say that a adopted son also got a right to claim for a compensation. I mean, we need to read it together, a minor, legitimate or unadopted son. I mean, what do you mean by this? A minor, he must be a minor. Who is a minor? Minor in the sense who is below the age of 18. In this case also, an adopted son also, he must be the age of less than 18. If that is the case only, they can claim for a compensation. Understood? Now, whether a minor, legitimate or adopted son, whether they need to prove that they are dependent, they need not prove that they are dependent on the earning of the deceased. They need not prove, because like widow, even minor, legitimate son or adopted son got an absolute right to claim for a compensation. They need not prove that except the minor son or legitimate son or adopted son, they need not prove that whether they were dependent on earning of the deceased or not during the time of the claim or death of an employee. A minor legitimate. I repeat my word, legitimate son, illegitimate son was not included in the first category. He is into third category. A minor illegitimate son included in a third category, not in the first category. I repeat my word, a minor legitimate son or adopted son. Adopted son also must be treated as a legitimate son. So, who is minor legitimate son? Those who have not attained stage of 18. 18. Hope you understood. Now, an unmarried legitimate or adopted daughter, look at here. An unmarried legitimate or adopted daughter, is there any age limit here? No. Whether they have mentioned the word a minor here? Absolutely no. Until her marriage, whose marriage? Legitimate daughter's marriage or adopted daughter marriage, she is the dependent on the earning of the deceased. I mean, during the time of the death of her father, the unmarried legitimate or adopted daughter got an absolute right to claim for the compensation. Claim for a compensation. Even if she marries at the age of 35, even if she married at the age of 35, still she can claim for a compensation until the age of 35. Imagine. And which facility was not available to the legitimate or adopted son. But when it comes to the daughter, so until she get they marry, so she can claim for compensation, whatever may be the age, even at the age of like 40, 45 years. So I repeat my word, unmarried legitimate daughter or adopted daughter, not illegitimate, legitimate or adopted daughter can claim for a compensation until she get married. Any questions? Any questions?
So you're saying all this in the sense of a father or a husband. What if it is the mother and the father has gone off before? I mean, father has expired before, and then the mother also, something happens to the widow. Then the same conditions apply for the legitimate son or daughter. Is it
I
the
didn't get
same
you.
situations that apply?
No, I didn't get you.
Sir, right.
Come again.
You are talking. Sir, now you are saying as it is. So now you're talking in the context of a father or a husband
Exactly.
who's died, right? All these.
Exactly.
So what
Exactly.
if the father has expired or the husband has expired, and then there is some issue with the wife also? So there's something with the wife.
Will come later because yeah, it happens. In fact, like in case say sometimes it may also happen in such a way that during the time of a death of a wife, whether husband was dependent or not. So those questions also will come. So I think like for all these questions, you'll get an answer after we discuss the entire the dependents list. So we have like three categories of the dependents: the first category, the second category, and third category. First category say that they need not depend upon the earning of the deceased. First case, absolute right. Second category, they should prove that they are wholly, not partly, they are wholly depends upon the earning of the deceased. That they need to prove. Third category, they should prove that either partly or wholly, whether they were dependent or not. Now, as you said, widow, yes, on the context of in the context of an death of an husband. This minor legitimate or adopted son, I mean, he got, I mean, we don't define the term here. When it comes to the employee, we don't discriminate on the basis of the gender, Shivani. Whether it is a male or female.
Okay.
Male or a female.
Okay.
Now, minor, suppose in case if there is no father, mother is maintaining, suppose during the time of an accident, suppose the female employee got expired, now like these people can claim for a compensation. Who can claim for a compensation? Minor, legitimate or adopted son. Unmarried, legitimate or adopted daughter, they can claim for a compensation. But when it comes to the husband, how, to what extent he can claim for a compensation during the time of the death of the wife? Now question comes, he must prove before the court of law that during the time of the death of his wife, so he was dependent on the earning of the deceased, either partly or wholly. He was dependent. He was dependent. In one of the case, both husband and wife, they were coolie and they used to earn, and they had they were pooling their money, and so they were running their family. Now husband was not running a show here, and he was running a family along with the income of the wife. Now during the time of the death of the wife, whether husband can claim for a compensation or not, my answer is yes. And I don't say the word husband, I use a word, the widower. Widower, not widow, widower. Being a widower, in case if he able to prove that he was partly or wholly, or either partly or wholly, he was dependent on the earning of the wife deceased, I mean, absolutely he can claim for a compensation. Compensation. I think exact picture you'll get once we discuss the entire all three categories of the dependence.
Okay, sir.
Clear?
Yes, sir.
Yes. Any questions? Any questions? Please ask. It is very interesting, in fact. I mean, this particular things which will be helpful for any, I mean, even other things like to define the dependence. I mean, in fact, like as per like a Hindu Marriage Act or Indian Succession Act or say like a CRPC. So I mean, so dependence. I mean, a similar viewpoint we can see, but it's not exactly the same. So little bit changes you could find, because here scope of these legislations we are discussing, please keep it in mind. So here dependence in the sense we are, I mean, the compensation in the sense we know that we are discussing only the compensation under the Code on Social Security or Employee Compensation Act. We are not discussing anything about the maintenance or other things under Hindu Marriage Act or Hindu Adoption Act or Hindu or Indian Succession Act or Muslims personal law. No, we are not going to discuss that. So here compensation we are discussing. For the purpose of the compensation, compensation in the sense, as I said, there must be accident. This accident leads to the injury, and there must be some which must be resulted in a death or the injury. So that we discussed. So this is, I mean, scope of this legislation pertaining to only these aspects. That's it. Don't think from the other point of view, like during the time of the death of the father, or say like the divorce, to what extent a wife can claim for a maintenance. So those part is not included over here. This is just with respect to the compensation can be claimed from an employer. That's it. Clear? Now,
Yes.
a widowed mother. Widowed mother. Who is a widowed mother? widowed mother, mother of an deceased, mother of deceased employee. When she become a widowed mother, when there is, when? During the time of death of the father, widowed mother. Now, widowed mother, you look at here, she falls in a first category. Why I press this word, the widowed mother, first category? Because widowed mother, she need not prove that she was dependent on the earning of the deceased. Whether she was dependent or not during the time of the death of the deceased, so widowed mother got an absolute right to claim for a compensation. Absolute right. Absolute right to claim for a compensation, widowed mother. Whether stepmother can claim for a compensation or not, so which is not clear in this legislation. Stepmother. In some of the decision of the court, I could see the interpretation, the stepmother, I mean, widowed stepmother cannot claim for a compensation. She can't claim for a compensation. But just now I read, as per the Hindu Marriage Act or Hindu Adoption Act, suppose childless widowed stepmother can claim for a maintenance. But for your understanding, I think like you may have some confusion. That's what I don't go ahead. I'll restrict my discussion just with the widowed mother. Widowed mother, she falls in a first category. I repeat, widowed mother. Widowed mother, she need not prove that she was dependent. Whether widowed mother and mother is same? Whether widowed mother and mother is same?
No, sir.
No. Now, whether when father is alive, whether mother can claim for a compensation in case she is not dependent? Because mother falls in a third category. That we'll discuss. Mother falls in a third category. Father falls in a third category. Since they falls in a third category, both mother and father both are alive. Since they falls in a third category, they need to prove that they were depends on the earning of the deceased. These they need to prove. Only in case if they are able to prove that they were dependent on the earning of the deceased, they can claim for a compensation, or else no. But widowed mother, she need not prove that she was dependent. She can claim for a compensation at any time, provided she must be widowed mother. Now, once again comes, what about a remarriage of the widowed mother? Whether remarriage disentitles her to claim for a compensation? Yes.
Sir, could you repeat the question?
Whether remarriage of the widowed mother disentitles her to claim for a compensation.
So if you consider it in the same situation that you had given for a widow, like the wife or the better half, then I guess no. I mean, she will fall under it still. Sorry.
Exactly. Yeah. So remarriage, I mean, which operates as a bar to claim for a compensation? See, court has some like different view. In fact, in one of the case, in the opinion of Madhya Pradesh High Court, mother would be entitled to compensation under this, even if she had remarried, provided that she can prove that she was wholly or in part depends upon the earning of the employee. I mean, they wanted to put under third category. Correct? In case if she remarries, she'll become a mother and maybe like stepfather, and she pushes back to third category. Third category. Correct? Now, but recent there is some amendment recently. This remarriage of a mother which operates as a bar to claim for compensation. The remarriage operates as a bar to claim for a compensation now. Bar to claim for a compensation. Because whether she is dependent or not, so she is not dependent. She is not dependent. There is a different divergent view on whether remarriage of whether to what extent which disentitles her to claim for a compensation. So we'll discuss. Category we'll discuss. I think like you'll be able to understand the mother father in the sense parent, mother father in the sense parent when can claim for a compensation, and even grandparent can they claim for a compensation. In case it comes to the grandparent, whether maternal or paternal, that we are going to discuss. We're going to discuss. Now, this is what we discussed. I hope you understood because you should be thorough with these dependents, because during the time of the death, suppose being a HR, so tomorrow if any person claim for a compensation, so you should know to whom or with whom this your compensation amount must be deposited before claim for any compensation. So we'll discuss it, and after that we'll wind up. Provide anyone want to read this?
Provided that for the purpose of Chapter 4, a legitimate adopted son who has not attained the age of 25 years shall be dependent on the deceased employee.
See, legitimate adopted son, we discussed in this case, I mean, adopted son we discussed, legitimate adopted son, we discussed for the purpose of compensation. What was the age I said? What was the age I said? I said 18 years, minor. However, for the purpose of chapter 4th, which one I said chapter 4th? Chapter 4th.
So State Insurance Act.
Employee state insurance. For the purpose of the employee state insurance, the legitimate adopted son, I mean minor, it means those who have not attained the age of 25 years. For the purpose of ESI, I'll discuss while discussing ESI for your understanding now. So for the purpose of ESI, a legitimate adopted son, he is dependent until he attains the age of 25, not until the age of 18. So his dependency continue till the age of 25. Maybe in order to protect his right and the interest, the age has been the extended till 25 years, until the age of, for the purpose of ESI only, not for the purpose of compensation. So his dependency continues till the age of 25. So those part will, I mean, other categories we'll discuss in a next class. In case if you have any doubt, so you can ask, or else like they will wind up this session, and the next two category, the second category 2 and category 3, so we'll discuss in a tomorrow's class. Fine. So thank you for attending.
Thank you, sir.